Hello, everybody.
Hello, everybody.
Hi.
Good afternoon and Happy New Year to all of our listeners. My name is Craig Vaughn. I'm the president of Castle, and I will be your host today as we talk about annual meetings, the pitfalls of annual meetings, and we have a number of questions that we're going to get through. As a reminder, you can chat in your questions through the Q&A feature on our webinar, and I will attempt to work those into the discussion and answer specific questions if we have time at the end. We have polling again today. We're going to put you to work in answering some questions. I'm going to jump right into that. Ness, if you don't mind posting poll question number 1, what type of community do you live in? So we can get a feel for our audience today, guys. It's annual meeting and election season, so I thought it'd be a good time to have a discussion on annual meetings and elections and to review some of the common pitfalls to avoid in running your annual meeting. To that end, I welcome back Jeff and Michael and our special guest today, Spencer Hennings, who's Florida's ombudsman. That's a mouthful, but we'll hear from Spencer shortly. All of whom are here to provide guidance to you guys with respect to your annual meetings and elections. Before I ask them to introduce yourselves, I want to remind everybody that Jeff and Michael aren't here to give you specific advice for your association. For that guidance, you should seek out your advisors, but rather to provide their opinions on the questions that you pose and the comments that you make. So guys, Jeff and Michael, quick introduction.
Sure. Hi. Good morning, everybody.
Good morning.
K. Bender Rembom is a law firm specializing in representation of Florida's community associations, sometimes developers who build them, and occasionally owners' claims if they're the right kind of claim. We represent over 1,400 associations at the present time. We have 19 lawyers, 8 of whom are board certified experts in this field.
Now 9.
9 now, and that's all we do day in and day out is practice association law. We have offices in Broward County, Palm Beach County, Hillsborough County, and even Miami-Dade by appointment. Let's see, what else can we tell you? My partner, Robert Kay, writes a column, Legal Morsels. I write Rembom's Association Roundup. Robert Kay hosts a radio show on a monthly basis. Our partner, Peter Mullengarden, hosts a radio show every Monday morning on 1450 AM. We provide all sorts of numerous webinars on all sorts of subjects throughout the month, so you want to stay in tune for that. And I'm going to hand it off to Michael to finish, but Michael chairs the CAI Legislative Committee and is very active with legislation, and we'll be hearing more from Michael on that, I'm sure, as the hour goes on.
Now, and I just want to say good afternoon, everybody. Again, Happy New Year. Jeff pretty much covered it. Our website, kbrlegal.com is where you can go to get all the information Jeff just talked about with the legal morsels, the roundup, the radio shows, the courses, and all that good stuff. Craig?
Well, Spencer, you'll notice they don't necessarily understand brief introduction, but that's okay.
Mine was very brief.
That was the brief one.
That is normal for us on these webinars.
You're dealing with lawyers, so.
I kept mine to 10 words.
That's so fun. Paid by the minute. I get exactly the problem. Spencer, can you tell us a little bit about yourself and your position?
Sure. So first, thanks off for inviting me on the webinar. I'm really thrilled to do these and market my office and the resources that we offer as much as possible. So thank you again. My name is Spencer Hennings. I'm Florida's condominium ombudsman. My office was created about 15 years ago by the legislature, and I was appointed by the governor to the position of the condominium ombudsman in July of 2020. We offer a variety of resources to Florida's condo owners and board members, community association managers, and attorneys as well. And I just want to specify this is for 718 condominiums.
Only.
So Spencer, welcome. Thank you guys. As always, pleasure to have you. We invited Spencer on today because while he represents and only provides guidance on the condominium 718, the lessons he's going to share with you today with respect to annual meetings and some of the things that are going on easily stretch across HOAs as well. So Spencer, thank you. And we're going to get more into what your office does and your team does shortly. Guys, so Marinus, will you just post the results of who's on today? Looks like about 55% condos, 58% condos and co-ops, and then which leaves the rest 42% for HOAs and 55 and better communities. Spencer, we call them 55 and better communities at Castle once James and I turned 55. So they're not 55 and older any longer, they're 55 and better. So just so you have the vernacular a little bit. Before we jump into the annual meeting stuff, I just want to touch on the emergency order. When we met last, it was just before the order was set to expire on January 3rd, excuse me. We did ask our listeners to project what the governor might do, and while 78% properly anticipated that our emergency order would be extended, just a small 38% were perfectly on target with a 60-day estimation. So I was one of those, of course, and I know that I'm very proud of that standing. I think it's now set to expire February 28th. Do I have the right date?
I calculated it to the 27th because it's 60 days from December 29th, first day starting the 30th. So I came out with the 27th. Michael, what'd you come out with on that?
I'm good.
All right, 27th or 28th.
27th, 28th, you know.
End of February.
Either way, because it's a Saturday, Sunday situation, because
Right.
the 27th is a Saturday. So it really,
For those who remember the old movie, Mr. Mom, you know, 32, 33, whatever it takes.
Guys, we're going to have another webinar, several before the emergency order will expire, but we are planning for our listeners to address what a board can do to prepare itself for the lifting of the order at a later date. So we'll revisit that. Couple of quick questions, Jeff. Does the emergency order affect annual meetings in any way?
Well, I think it can affect annual meetings through the emergency order, because the emergency order, remember, provides the boards the ability to cancel and reschedule meetings as may be necessary, to conduct board meetings and membership meetings with notice given as practicable as possible. But there really needs to be a nexus between use of the emergency power itself and the situation on the ground for that particular association. You can't just use the emergency powers because, oh gosh, you want to, and we're in a state of emergency. You need to have a justifiable nexus between what's happening. Maybe you have a high incidence of COVID or what have you taking place at the association. But I don't want the listeners to get confused, because we don't need emergency powers per se to hold our meetings electronically and virtually, which we'll be talking more about as the hour progresses.
Mm-hmm. So, Michael, do you think, can we skip or postpone it? I mean, it's bad practice maybe, but from a practical standpoint.
Yeah. Well, I think Jeff touched upon that. You know, you certainly, there's the ability to postpone as needed. I think skipping I think skipping completely is obviously not gonna be in your best interest. That said, I think it's also a community by community situation. There are some communities that I'm aware of that have, have very few people who ever attend. They have no candidates. They only had 3 candidates for 3 seats. And so they didn't expect to even have a quorum. So in that regard, I think they sat the board, but then they offered to hold an annual meeting if the owners desired one. So I think that's a way to go about it, but you really need to judge your situation. I wouldn't just automatically skip anything. I mean, you have an obligation to have an annual meeting annually. That said, let's use some practical common sense here.
And there's no reason why you can't have the meeting with all of the services that are available today. To be
right. Well, and that's true. And you can always do that. And I will say this: if you don't establish a quorum, which happens, but you have, say, I mean, this community had 5 people show up out of 500 units. Well, those 5 people, you can let them share some thoughts, comments, concerns if they have any, because they took the time to come out.
Right. Spencer, I see you nodding your head. You agree?
I agree. And I think it's, as was stated, best practice to have the election in a safe way. I don't recommend associations to cancel their elections.
Excellent. Okay, guys, one more housekeeping matter. Our listeners have always said they'd like to know what their neighbors are doing. So we just want to check in, especially in light of the increasing number of positive tests we're seeing in Florida, on whether or not associations have changed their use restrictions. So Ness, will you post question number 2? And then Michael, we're right into snowbird season. We're in full swing. Can an association require returning residents to quarantine or get tested, in your opinion?
Well, in my opinion, no. Simply put, the governor's order on quarantining for out of state was lifted months ago. I think we talked about that probably at a previous, I know we talked about a previous webinar. So no, there is no, and I don't believe an association can adopt rules that would require someone to be locked in their unit. In fact, there's a recent case that's out there, a situation that happened in a community that's in the, I think, north central part of Florida,
Saw that.
where they were, where I think they were, I don't want to speak to the case because I'm not involved in it, but, and I don't want to misstate facts. But no, you can't require them to. You can certainly request, you can certainly urge, you can ask them perhaps if they would steer clear of the common element or amenities until they get a test that shows that they're negative, but you can't mandate it.
Okay.
That's my opinion.
Guys,
I'm sticking to it.
everybody agree? Good. Okay, Ness, will you post the results of that question? With the increase in cases in the last month, has your association made any changes to its amenity use restrictions? Some increased, some actually decreased, which is interesting, mostly unchanged, which I think is to be expected. The decrease is a little bit of a surprise given the increasing number of cases, but you know, that may be a question of they still didn't have their pool open and decided to open it part-time.
Right, exactly.
When we looked at that, about 95% of people had their pools open, so some people didn't at all, and maybe they've decreased that. Okay, let's jump into the office of the condominium ombudsman. I think we'll just go CO, office of the CO. It's way better. It's less of a tongue twister.
Not bad.
But before we, let Spencer talk to us about that. Ness, can you put poll question number 3 up, which is how many of our listeners have had concerns, disputes arise out of their annual meeting and election process?
So you don't mean fist fights at the annual meeting?
No fixed, but excluding physical violence. I didn't add that as a category, but just, you know, knowing our audience. But Spencer, tell us about the Office of the Condominium Ombudsman, your role and what your team does, and also what they don't do.
Sure. So we're based in Fort Lauderdale, which I think is good because, you know, South Florida has the most concentration of condominiums throughout the state. So I think it makes sense to have the office down in South Florida rather than Tallahassee. So I'm the first ombudsman that actually lives in South Florida. I live in Brickell. I live in a condo in Brickell. As far as our office, we do offer a variety of resources to help people throughout the state. Perhaps the most important thing that we offer is election monitoring. So a petition gets sent to our office and we verify that petition. And then we send out an election monitor who's completely independent and neutral and experienced, conducted hundreds of condominium elections to go conduct your association's election on the day of the election from beginning to end. And when that happens, you know, I can promise that if you do obtain an election monitor from my office, you will have a fair election. And I've seen amazing results from election monitors. Aside from election monitoring, we do dispute resolution, which is sort of a mediation process. It's not something that takes the place of litigation or arbitration. I don't have the authority to issue holdings or sanction associations, but more so when an issue pops up that can be solved creatively with a couple phone calls or a couple emails, I'll jump in and get it resolved that way. And I think that's preferable to it having to go to litigation or having to be an official complaint with the Division of Condos, Timeshares, and Mobile Homes. We also offer education. I'm working on a whole webinar curriculum that's going to be about your rights as a condo owner and your obligations and rights as a board member and things like that, and record requests and elections and annual meetings. So I'm really looking forward to launching that. And lastly, I'm responsible to make legislative recommendations and policy recommendations to the governor's office and the legislature regarding condo law and policies.
In fact, we're going to ask you about that later, what you kind of have on your wish list. So we'll visit that. How is your office funded?
Sure. So every condo unit owner in Florida pays a $4 fee to the state, and that goes to a variety of things, but it does fund our office.
Are you going to make sure they keep it aligned to the condo ombudsman's office as opposed to stealing it for something? Oh, that's another issue. We'll deal with it.
That was my question too, Craig.
If I am a board member, if I ask you to monitor my election, how much does it cost?
Sure. So it's a sliding scale, and I actually have our chart right here. If you have under 25 units, it's a flat $250 fee, which again, the association's obligated to pay, and everyone splits it. in my mind, it's very, very worth it, especially if you have a contentious situation. And then if you have a big association with over 150 units, it's a $2.50 fee per unit plus an administrative charge of $125. So really what you can expect, what I see is anywhere from a few $100s to $1,200 or $1,300. And again, that's split between everyone.
And then how many people in your office?
I have 7 full-time staff members in Fort Lauderdale, great team. We're super busy right now. And then in addition to that, for the election monitors, I have about 20 of them throughout the state who are independent contractors with the office.
Outstanding. Well, it's very exciting, and I know that you're bringing it full frontal, if you will. Like we're seeing you around and hearing your name, and I think it's a great thing and a great service for those contentious type election services. Keep in mind, listeners, Spencer's office only represents condos, only deals with condo associations. So, Jeff, I want to ask you if an HOA thinks it needs a monitor for its elections, what should it do? Who should it call?
Well, there's a few choices. Some associations choose to have their local counsel there, right? They can have the lawyer for the association. There's been on occasion, I have been retained by an association that I don't represent on a daily basis, perhaps a peer does at a different firm, and they call me because they want somebody neutral who will absolutely have no relationship to anybody on the board at present, and then run the election that way. There's lots of different ways to do it. I would also imagine that you can't do it necessarily through the ombudsman's office, but I imagine some of those independent contractors that Spencer has would make themselves available for HOA elections and running those elections as well.
They absolutely do. And
What's
you know,
the best
they're
access?
Is there a list that they can go, like, can someone go somewhere and find a online list if they're in an HOA and they want somebody from your office? Not from your office really at that point, because now they're completely independent.
Sure. So for liability purposes, I don't recommend election monitors unless I'm actually appointing them. But I suppose our list of monitors, just like everything else in our office, is subject to public record requests.
Right.
So if someone wants a list of monitors that we do appoint, they can obtain that for HOAs. And most of them that we do appoint also work with HOAs on the side.
Okay.
Fantastic. I think I'm gonna post the results of the question. I think you guys will be amazed. I'm a little amazed. Have you had any concerns, disputes arise out of your annual meeting and election? 35%, 34% of our listeners have said yes, which is a lot, right? There's to me that seems like a lot. Now some of them might be minor, major. We're going to get into some of those things and how do you avoid them, but looks like big demand for your office. It's no surprise that you're busy, Spencer, for sure, given those results.
And Craig, I'll just add on to that. It's not just unit owners that do the petition for an election monitor. Many times it's boards because they want to prevent anything improper from happening at the election. They want to show the unit owners that they're being transparent and that they're acting fairly. And they also know if there's an election monitor there, the chances of a challenge happening to the election afterwards are decreased substantially, if not eliminated completely. So it's a great program, and a lot of boards initiate it themselves.
I was going to ask you how, if I'm a board member, I can make a call to your office. If I'm an individual, can I call your office? How do we access the services of the ombudsman in the office?
Sure, you can call or you can email, and I will put the contact information in the chat box at some point during the webinar. And
only one, like as I'm a resident in a 2,500 unit condo, I can just call you and say, I think you need to come, or? So it's a petition. There's a process. We need to obtain the petition with at least 14 days before the election. So I recommend that you submit it as soon as possible. And what it requires is 15% of unit owner signatures on that petition. That's 15%, or 6 units, whichever is greater, be that 15% or 6 units. Right. And then we validate that petition and make sure that the people that signed it are authorized to sign it are unit owners. And then we appoint a monitor. And just for clarity, not co-ops, condos only, right? 718? Correct. Only 718 condos. And that is something that I'm hoping can be changed by the legislature. But at this point, I only have jurisdiction with the condos.
The co-ops pay their $4.
Yeah, that's right.
And be careful what you wish for, Spencer.
Exactly.
Well, I think it makes sense because as of now, even if there's a master association that has a couple condos in it, I can't monitor the master association's election. And I can't even get involved with issues as it relates to the master association, which many times it does.
Mhm.
Interesting. Okay, guys, let's move on to the actual meetings now. And I think there's a bunch of quick hits in these questions, so I'm just going to pose them. Michael,
Yeah.
Two-part question. Does an HOA have to have an annual meeting? I think we've talked about this a little bit, have to have an annual meeting and election. And what are the rules governing annual meetings and elections?
Well, I mean, the short answer is, does an HOA have to have an annual meeting? Yes, there should be having an annual meeting annually. Whether an election is required, in most instances, you'll have the documents require an election each year. HOAs are really, unlike the condominiums. Condominiums are a creature of statute far more than the HOAs. So in HOA, you really are looking to the governing documents, and that's typically the articles of incorporation and bylaws of the HOA to ascertain the process. There is Chapter 720 does have some requirements with regard to the annual meeting process, but they're minimal. And so in large part, you defer to the governing documents. And so when you say, what are the rules governing annual meetings and elections? The answer is it would depend on what your documents say, how they read. And absolutely, you should be reviewing them with counsel and making sure that you've got your process in place, your notices being done properly, mailed timely. And I can tell you that some HOAs have a 60-day notice requirement for an annual. Some have a 7-day notice requirement or less. And either of those are legal under the law.
And Jeff, condos, anything different? It's a little more regulated, as you said.
Sorry, I dialed out for just a second. What was that, Michael? What were you?
No, there with differences for a condominium for the election versus an HOA. The condominium is creature statute, as we mentioned, and that has your 60-day notice requirement for first notice. You send out your notice of intent. Any interested eligible candidate has 20 days, essentially 40 days prior to the election date, or typically 20 days from when that notice has been sent out to say, I'm interested. 5 days after that to put in a candidate information sheet, or 35 days, and then anywhere from 14 to 34 days prior to the election, the second notice goes out. And if there is to be an election, that'll include the ballot, that'll include the inner envelope, outer envelope, and the whole process that Spencer's office handles.
I'd add to that too, that you don't need the quorum for the condo election. You just need 20% of the eligible voters to cast a ballot.
Actually, that's an excellent point. If I can, Craig, just reiterate that. Thank you, Jeff, because I did not mention that. The HOA, the one big difference between the HOA and the condominium, again, the HOA, your governing documents might have some quorum requirement. And we've had a lot of HOAs, or I shouldn't say a lot, we've had some HOAs amend their documents to make them more condominium-like and provide that there is no quorum requirement. You just need a certain number of owners to vote. But to Jeff's point, in the condominium setting, most condominiums have a majority of the members quorum, some only a third. But regardless, if 20% of the owners submit a ballot in a condominium, then you have your election. So you have 400 units. If 20% of 400, is that 40? Because I understood there'd be no math, so I brought that on myself.
You did.
So, right, so you have 400 units. If your quorum is a majority, you need 201 owners to show up to hold your annual meeting. You only need 40 owners to submit a ballot to conduct that election. So that's where a lot of condominium owners, I'll go out, conduct an election and say, guys, we don't have quorum, and they'll all be a gasp. I'm like, but we're still holding the election. Apples and oranges.
And you know what else is
Great point.
interesting too? Is in the condo setting, we have absentee ballots, and you have to use the inner outer envelope system. And it doesn't matter if you walk in the door and you want to vote at the meeting and you're there live, you still have to use the inner outer envelope. In the HOA setting, when they're using absentee balloting, so if you're not present, then you'll use the inner outer envelope. But if you walk in, more likely than not, you end up voting on either by ballot or by proxy when you actually walk in the door. So there are some subtle differences and traps for the unwary here.
And Jeff,
Sure. And I just wanted to add on before we finish. Go ahead.
Go ahead, please.
Sure.
Jump in,
I just wanted
Spencer.
I wanted to add to something that you said, Michael. My office can advise condos on the entire noticing and election process. But as far as monitoring the election, the only authority we have with regard to the election is to come in and actually conduct the election on the day of the election. So I can't go into the association and print the ballots and mail them out and make sure that the noticing was done properly. but the jurisdiction is limited to the actual day of the election. I just want to clarify that for the listeners.
Interesting.
And guys, so for condos, it's very specific. 20% of the ballots cast constitutes an election. Jeff, what are the rules in HOAs? Are there specific? We got a lot of questions of, I haven't had an election in 10 years in my HOA because I can't get quorum or I can't
Well, then you're going to have a rollover, probably, depending on whether they will allow nominations from the floor or not. We have some changes in the legislation on that. But essentially, unless the bylaws provide for a lower percentage, then it's you need a quorum in the HOA to have the election. Some of my HOAs have begun to bring in what I call the football when you're in the huddle. 60, 40, 35, 14, hike, right? 60 days before the election, as Michael was explaining, you're sending out the first notice. 40 days prior, you have to let the condo know if you want to run. Then the 35 days for to give them that beautiful one-page CV all about you. And then the second notice, 14 days. So a lot of HOAs are starting to bring that into their bylaws,
Right.
which is interesting.
It is, and we've seen that as well, just so that they can have an election. So, as opposed to this board.
Right, and they're bringing in the 20% requirement. We don't need a quorum for our HOA election. We only need 20% of the eligible members to cast a ballot, and then they're finding that they are having it. The other thing that's happening in the marketplace too, it's really changing the game, is the electronic voting.
Right.
All these associations that have member apathy because nobody is voting, if you can get the membership to opt in to electronic notices and electronic voting, oh my God. And then when you're at the meeting, instead of being there till 2 o'clock in the morning, oh my gosh, 5 minutes later, you have the results. It's so wonderful.
We're going to talk about some of that.
Yeah.
So let's hit on some of the, I guess, what happens that a meeting goes astray? Like, what do we need to make sure we're doing to make sure the meeting is right and the election is right? Jeff, can you start us off in terms
When
of?
we had talked about that, we really talked about it in the electronic context. Is that what you mean on the virtual side or just in general?
Just in general. So you had mentioned to me yesterday, often the notice, very simple. The notice is wrong. The date is wrong.
Or they leave out a bio.
So I'm really.
Oh, critical flaw. Boy, if you're in a condo and you leave out a member's bio, you may as well just pack it in and start over.
Unless you have more than 14 days.
Good point. That's right. You can catch up to
So the point is, if you remember in a condo setting, you have minimum 14 up to 34 days. If you happen to send your mailing out, say 21 days before, and someone says, oh, you left out my bio, and you still have more than 14 days, you can send a corrected notice and keep the election on that same day.
There are very few membership mailing packages that we review for clients that we don't find errors in when they prepare them on site and then ask us to review, which is really indicative of you can't have too many eyes look at these packages before they go to the members. When we're here internally, sometimes we'll even bring 2 lawyers in to look at it because you'll get 2 different perspectives and somebody might find something that someone else missed. There's a lot of technicalities when you're looking at these notice packages. So you really want to make sure the I's are dotted, the T's are crossed, the dates are right, and everything matches up correctly.
Of course, that would be for every association other than those managed by Castle, I'm sure. But
Of course.
But seriously, if we, let's take a condo, if we miss including a bio, start over. That's the.
Well, no, not necessarily, because as Michael said, you might have time to cure that problem. So as soon as you discover it, you need to get on the phone with the association's lawyer and see if we can't still save the election and save postage and not have to start all over. And then when you do start over, sometimes you would start over. You may not have to start over from the first notice.
Right.
You already know who your candidates are. So you would just do a new second notice. And when that occurs, we advise the clients, if you have to do it from the second notice, then you absolutely want to use different colored paper. Simple things that you don't always think about, but you want to be able to differentiate the first package that went out, the items you received back, from the second package you sent out and items you received back.
Right.
So dot the I's and cross the T's early to avoid, paying later, I guess is the real question.
Well, and just what Jeff just led to, even just the description, you could see he's spot on, but you could see how tedious that becomes to the board, to the management team. Because the situation is when you're voting, once you've voted, you've voted. So, but in a situation where if you didn't send out the full packet and you have to resend the packet, someone might claim, well, wait a minute, I now know more about this candidate. I would have voted for them. So it's important that you be able to discern, hey, the white ballot was first, the orange ballot, they say, is second, and you have to discuss with your counsel what's right, what's wrong, and what you can and cannot do in that scenario.
Can you suggest that this is a 1-page bio, it's 2 pages unlimited? Can you set those guidelines?
By law for a condo, Spencer will tell you that it is limited already to the, sorry, I'm taking away your thunder, Spencer, but it's 1 page, the front page of an 8.5 by 11. And most of the HOAs have that same language.
Yeah, but you cannot edit it.
And I can't change a word.
You know, if someone says something that you don't like, that's unfortunate. If someone says something that's potentially defamatory, then it gets mailed. And if those individuals who feel defamed want to bring some kind of legal action, that's their right. But the association does not have any discretion. The manager does not have any discretion. The board members have no discretion saying, I don't like what that says. Don't send that out.
Or will you type this for me? I've had that happen. No, the association can't type it for you either. You can't force the association to, you put in a beautiful color glossy. The association just does it on black and white.
So Spencer, I see you nodding your head. You get into lots of disputes. You hear lots of things. I'd be interested in what, you know, you're being called on to monitor when you come in, and what kind of disputes you're hearing, you know, some stories from the trenches, if you will.
Sure. A lot of times it's just a contentious election and people are afraid that the incumbent board is going to do something improper, or that, you know, everyone has allegations against their association's attorney that the attorney is going to be acting improperly and trying to disregard ballots. I'm sure you guys have heard things like that. You know, usually they're not true. Usually they're not true. But, you know, I show up and I go to as many of them as I can. And, you know, I very, very rarely, if ever, have any issues with the attorneys there. But, you know, horror stories, I have had a couple horror stories at the elections, and those range from things like the association trying to prevent people from giving ballots to the monitor, which did not fly, and the monitor did collect the ballots. And I think that's one of the best things the monitor does, is allows people to hand their ballot directly to the monitor, so they can know for sure that ballot is being counted. But here's the thing, because it's a state affair at this point, the association doesn't really have the ability to do anything improper at the actual election. So what I see more so are illegal or improper acts that happen in the process leading up to the election. What I see most often is associations improperly trying to keep people off the ballots. And they usually do this by inventing fraudulent charges and putting them on someone's ledger, because as you know, the law states for 718 condos that if you're delinquent in any monetary obligation to the association, you're not eligible to run for the board, which I think is a good law, but it is manipulated all the time to keep people off the ballots and to perhaps even prevent elections from happening at all.
I've never seen that one. I've never seen them actually go out of their way to create the false ledger. I've heard about it.
That limitation, by the way, that Spencer pointed out, also applies in the HOA setting. That same, you know, you have to at the date, and the key is on the day your candidacy is due, which in the condo we talked about is 40 days prior to the election. In the HOA, it could be the day of, because if you take nominations from the floor. But if you have if you're delinquent with any monetary obligation, and I have had scenarios where they've been investigated by the division, and they mean pennies. If you have pennies, you know, a late fee or even interest that was somehow on the account. So what that means, if you're interested in being a candidate, the onus is on you to ensure that you have a zero balance on the day that your ballot, your notice of intent is due.
Right. Always easier to pay it, because usually we're not talking about a grand sum of money, usually. So it's usually easier just to pay the few dollars and then go fight over it later if you want to be on the board, because otherwise you're not going to have your opportunity to put it on the board. I've got 2 quick horror stories if you want to hear those. That are pretty. One simple condo. They opened when they were doing the registration. First, they didn't notice that they were going to be looking at the envelopes, and then one of them opened an outer envelope. And that's it. It killed the election. They had to start over from the 14-day notice package. It completely invalidates. The other one is more interesting. Condo again, where an individual board member kept getting elected every year, and no one could quite figure out how. Turned out most of the 80% of the owners in this building lived overseas. Over time, the president, who had been president for multiple years, knew who voted regularly, sort of, and who didn't, and just took, you know, we had fake ballots coming in. Fake in or outer envelopes, the whole thing.
Yeah.
Well,
It's crazy.
Those are rare, but I guess they happen.
I
And
think
Craig, I do have to your question about a challenge that the associations face. This is one of the ones I think that is important to bring up. It's the voting certificate requirement. This is something that is, and this could apply in all communities, and it's very important. Two things: one, that you ascertain whether your governing documents have a voting certificate requirement, and what that means, in short, is if you're the sole owner of a unit, you vote for your unit. But if there's multiple owners of a unit, including husband and wife, the documents may require that you have a certificate on file signed by all owners of the unit that designate who votes for that unit. And I have many communities which include a husband and wife. So the husband and wife will have to sign the certificate saying that the wife is the voting representative. Part two of that is, does the association then enforce these requirements? Because at least in the condo setting, and since the division does oversee HOA elections, I assume they'll do the same thing. If you don't enforce them, basically you've, like anything else, you waive the ability to enforce them. You can't suddenly decide we're going to start using this unless you've notified the membership, hey, we're putting this back in place. So be aware if you have a voting certificate requirement, because in the husband-wife example I gave, if the husband and wife both sign that the wife is the voting rep, but then on a condo envelope, the husband's the one that signs the outer envelope, I'm disregarding that as not in compliance with the voting certificate, presuming that the association has confirmed that they do use voting certificates at all votes, elections, amendments, etc. So that's the voting certificate requirement is very, very, that's where I see a lot of questions come up, a lot of challenges, a lot of confusion. So get that clarified well in advance of your election.
And I don't want to confuse our viewing audience, because usually everybody, and Mike, it was a really good example that you gave, but usually the husband and wife, when you read the designating voter certificate requirements, it'll typically provide, if it's owned by husband and wife, so long as not more than one ballot has come in, that you don't need the voting certificate at all. Usually it would appear, let's say Joe and Mike own a unit together, and for whatever reason, tenants in common, not married, then in that case, you would need the voting certificate.
And corporations or business entities, or even really properties held in trusts.
Right. Exactly.
Those are the things. But the reason I mention husband and wife is because most instances may read like Jeff said, but there are some that even require the husband and wife. Just know your voting certificate requirements and enforce them. They're there for a reason. Enforce them.
And you know what it comes down to too? Read your bylaws. Everybody out there, 332 right now. When's the last time you read your bylaws before the annual meeting? You didn't know you were going to get homework today, but you got homework. When's the last time you turned the pages? Look at them, turn them. I can't emphasize that enough.
Right. And just so we're also clear, guys, declaration, articles of incorporation, bylaws. A lot of times people hear the word bylaws and think that means the declaration. You have your declaration, your articles and bylaws. The articles and bylaws create your corporate entity. That's where you'll primarily find voting certificate requirements. That said, you still need to check your declarations because sometimes they're in there too.
And how do you remember that? How do you remember that order of priority that Michael just shared with us? It's that 1970s Brill Cream commercial. You'll never forget it once I tell you. A little dab will do you. Deck, articles, bylaws in that.
Oh, wow.
Little dab.
Look at you. Look at you with the acronyms.
I like that.
Slam a jar.
Guys, I think one of the comments I have.
Well done.
I have two questions. Number one, I think, you know if you're going to have a contentious election, if you have that guy or those guys or that couple that's going to make an issue. And it's so technical. It's great to have the attorney there because inevitably something comes up, a voting certificate issue. One of my favorites is when as soon as you say that the balloting's closed, 5 people come in with ballots right after, at the door. So what do you do? How do you deal with those people? What are your thoughts? You close the balloting and then you're done, right? You don't accept anymore. That's how it works.
But who closed the balloting? Did you close the balloting, or did you entertain a motion from the membership to close the balloting?
By the way, that's what I do.
That's what I do.
Okay.
Because then everybody goes, no. Otherwise, if the board makes a decision, no, you're being unfair and all of those types of things. But again, a great reason, if you're in a condo, you just heard the cost, very reasonable. If you think you're going to have an issue, it's going to cost you more money after to resolve an issue than get in front of an issue, I think, at the election.
Absolutely.
Well, and Craig, I'm glad you brought that up because that's a great point too. In the condo setting, and some HOAs are run like a condo, the issue of when voting is closed is set forth. I mean, it's not, when you're verifying outer envelopes, people can continue to submit their ballots. It's once you're finished and you're about to open that first outer envelope, that to all of our collective point is that's when I'll say, we're about to do this. I entertain a motion to close the voting. And I also let everybody know, listen, if somebody runs in 5 minutes, you got my back. They don't get to vote.
Yeah, that's a good idea. Okay, one more question on elections, then we're gonna get to virtual meetings. But are there if you owe any amount of money, 10 cents, at the time that you submit, you are not a valid board potential candidate, right? That's the case. Any amount.
Any amount.
One penny, Craig will do it.
HOA and condo, same.
Right. And keep in mind, that's not just for assessments. If you owe a fine, if you've damaged property and you owe money for that, any monetary obligation is how the statutes read.
Okay, and is there anything else that would disqualify me as a potential candidate?
Arguably a felon if your rights haven't been restored for at least 5 years. That's still on the books.
Right.
Where are we with the 8-year rule?
I just want to say one other thing also, to your point, Craig, you have to look at what the documents require for eligibility.
Mhm.
Many communities say you have to be a member. How is a member defined? Is it a record title owner? Is it a member and their spouse? And then some don't have that requirement. Some will say that you don't need to be a member, and that means anybody could run for the board. So
Right.
it's very important that you look to the governing documents. And I want to point out one last thing, because this just came up. Guys, articles of incorporation, the language in the articles will control over the language of the bylaws. The articles are they're like the stepchild that nobody considers. But if the articles say you need not be a member to serve on the board, and then the bylaws are amended to say you need to be a member, you caused a problem there if you didn't amend the articles. So keep that in mind and amend your articles as well.
Good point.
And then what about the 8-year rule? Where are we on the 8-year rule?
Simple.
So the state's position on the 8-year rule is that it's not retroactive, meaning when it was enacted in law in 2018, that's when the 8 years starts ticking. Essentially,
There we go. Thank you,
And you heard
Spencer.
it from the ombudsman himself, right
Yes.
there,
Yes.
everybody.
Essentially, it's not usable as a tool for associations until 2026.
Exactly.
And what about HOAs? Does it affect HOAs as well, guys?
Well, remember no. This was actually no. This was only in 718.
Yeah.
So, okay, and hopefully in 2021 we'll get legislation passed that will officially confirm. But thank you, Spencer. It's great to hear because Jeff and I have stated this, as many attorneys have, but it's great to hear the ombudsman's office now putting the state's position forward as well.
And Spencer, you don't have to answer this one. I'm not putting you on the spot, but it's now we're going to project forward. It's almost 8 years. And the director who wants to run again is in his 7th year, 11th month, and quits for 3 days. And he no longer has 8 consecutive years. Can he run again? We're going to see those issues coming
Yeah,
up.
we are. We're definitely going to.
Fix that legislation.
Yeah.
You got about 5-6 years to work on that, Spencer.
Exactly. Okay, guys, let's jump on to virtual meetings. We have a bunch of questions. I want to start, Nez, by posting a poll question. How does your association plan to hold its annual meeting this year? Let's see what people have to say. Let's move that over. So, Michael, first question to you. Does the board have the authority to hold a virtual meeting?
Yes.
Okay, end of story. That's good advice. Spencer, any concerns on the condo side?
No, I advocate for associations to hold meetings on Zoom. I think that's the safest way to do it, and I think it encourages participation. And now you have people around the world that might be unit owners that can now, attend the meeting virtually that otherwise would just be in the dark and have no clue what's going on in the association. So I think it's a great thing on Zoom.
We've talked about a lot of board meetings being held virtually and by Zoom. Annual meetings are a bit of a different a beast, mostly because of the importance of what's going on. Not that board meetings aren't important, but also just the scope and the number of people and elections and all those types of things. Jeff, are there any guidelines you think our board should follow specifically if they're going to have a virtual meeting?
Absolutely. Now we're talking membership meetings now.
Membership meeting, yeah. Annual meeting, yeah.
So there's 2 statutes really we need to look at. We need to look at 617-0721, and I'll say it again in case anybody wants to read it for themselves, 617-0721. If, and this is about virtual meetings, if authorized by a board of directors and subject to such guidelines and procedures as that board of directors may adopt, members who are not physically present at a meeting may, by means of remote communication, participate, and be deemed to participate. Now, what does this tell us? First, let's go back. If authorized by the board. So what does the board need to do at a properly noticed board meeting? They need to say, I make a motion that we have our annual meeting and do it virtually through a Zoom platform. Second, discussion by the board, out to the membership for comment, back to the board. You've got to guarantee the members have a right to speak. This is both for board and member meetings now. When it comes to the members' right to speak, it's not the members' right to submit written questions, everybody. It's the members' right to address, as we are addressing you now, verbal communication. You've got to account for that. You've got to provide clear explanation of how the meeting is going to be held, and if there's going to be slightly different procedures in voting because of the meeting being held electronically. So you really need to go into detail and inform everybody. The simplest solution for some of these things is to get everyone to opt in to receive their official notices electronically and to opt into voting electronically. But if you're opening ballots and counting votes in an electronic meeting, you absolutely want to make sure the members can see, you have a camera, so that the counters that are in the physical room may be the only ones there with the manager, maybe the lawyer, maybe someone from Spencer's office, but you want to make sure the members can see every envelope being opened.
I'll even say the candidates. I'll even include the candidates want to observe in person, but outside of that, then everybody else should be on camera being able to see it.
You know, and Jeff, to what you said about watching the opening of ballots, you know, I think that's great. Unfortunately, you know, as you know, on Zoom, you're not going to be able to see with enough clarity to actually see the ballots, but you get to see the process.
Right.
And then afterwards, of course, the association has to maintain those ballots for a year, so everyone can go in and look at it after. And one thing I'll add about the election monitors that my office appoints is after the election, they submit a full report of the entire election, the number of ballots.
Yes.
That's to you or back to the association?
To me. And that includes if anything was disregarded, why, anything wonky that happened at the election, rules on voting certificates, basically a full overview of the entire day of the election. And then if you're a unit owner or a board member, you can obtain that from me. Just send me an email. I'm happy to send it to you.
Awesome.
And
I've seen those reports. They're comprehensive.
Yes, yes. And you can, if you're a unit owner and you think that anything improper happened, you have that report, you can view the ballots. You'll have everything that you need to clarify any discrepancies or use as evidence for a complaint afterwards if you feel that you want to challenge the election.
That's good
and
stuff.
just so everybody knows, I know Spencer, you intend this. It's not only the ballots that you're maintaining; it's all election materials. So you're holding the inner envelopes and the outer envelopes as well as the ballots.
Correct.
Guys, one of the questions we get asked is, can you adopt rules to how long people can speak? We've talked a little bit about it before at a meeting, because there are a lot of questions of the community has that guy who disrupts the meeting. You know, what tools do we have in our tool belt to deal with that situation?
Well, you're on point there. We talked about it last time. It's clear, reasonable rules governing meetings can and should be adopted by the board at a properly noticed 48-hour notice board meeting where that's an agenda item, and have meeting requirements. Get with your council to discuss what they'd recommend, and then decide as a board from those recommendations what you want to accept, what you want to modify. But yes, you can certainly limit the amount of time a person can have the floor. 2 to 3 minutes seems to be pretty standard. And you can Jeff, I don't know if there's anything more you want to add, but that's pretty much
I'm
what
more
I'd
of a
say.
fan of 3 minutes.
Yes.
There should be rules in place that everybody has to act as an officer, lady and gentleman, that you can't give your time to somebody else. To be considerate. If 10 people have made the point already, there's no need for you to make the point. You can just say, I agree with Joe. Just because you ask a question doesn't obligate the board to answer a question. That we have prepared at the firm for those clients that want it, a whole host of guidance that they can pick and choose from, basically a smorgasbord of all those types of rules together. And then we whittle it down as to what's appropriate for that community. But the bottom line is, if you act like an ass, you abrogate your right to speak.
And can a board member or whoever's conducting the meeting mute them if they're on Zoom? Literally,
You bet.
You're done.
Yep.
What do you recommend with respect to questions before the business of the meeting is conducted or at the end of the meeting?
My favorite subject. I'm going to jump in on this one for sure, right? Because the law does a disservice. They don't tell us in the statutes when the member gets the right to speak. So let's say the board decides the member should have the right to speak at the end of the meeting. I think that flies in the face of the legislation itself and kind of slaps it aside because the decisions have already been made. What good it does those points matter? Some associations treat it like a local government and say, okay, everyone that wants to address something on the agenda, line up, tell us before we start our actual meeting, so to speak, go into the business. I am not a fan of that, but I can't tell you can't do it. I just don't like it. It doesn't seem right. The best time is when you adopt a set of rules. And I have clients that actually put this on every agenda, that the member's right to speak will occur. Once members know when they get that right, it takes all the acrimony out of the meeting, because they don't have to sit on the edge of their seat because they want to tell you something and it's so contentious. So if no motion is made before going on to the next agenda item, every member will get their right to speak. If a motion is made and it receives a second, then the board will discuss the item ad nauseum till it is complete with its discussion. Then it will go out to the member for membership comment, then back to the board for final uninterrupted conversation and vote tally. That's when it should happen. And I wish the legislation would catch up to that. Hint, hint, Spencer.
Well, yeah. Oh, well, again, and I agree with Jeff 100%. That's what we recommend as well. That is best business practice with one caveat. Board meetings are for the board to conduct association business. If an owner or owners are there and precluding the conducting of association business by their behavior, the board may have to modify when they're going to allow owners to speak. That may be where they just get through their business and then say, if you have anything to add. Like Jeff, it's not recommended. Most boards, I think almost all boards that I work with, do have an agenda item, throw it out to the membership, discuss, vote. That's the way it works. But those of you who are attending board meetings, you need to understand that it is a board meeting and you're a guest there, and you're a guest with impact. You're allowed to be there, but you have to allow business to be conducted.
And if they have their 3 minutes right to speak, I have no problem, especially, when people are paying the kind of money they pay for us to go to meetings. There's either a legal reason why, a hyper-technicality type reason, something with the election going on, or they've lost control of the room and they know they're going to have that membership out there that's not going to let them conduct. So they want maybe a more firmer hand at the meeting. But I have no problem bringing undercover police sometimes, in uniform police sometimes, and I have no problem excusing members from a meeting when they misbehave.
And that should be in the rules.
Yeah.
You get a warning, and after that, you're excused.
Does the 3-minute rule apply to the board as well when they're addressing the business of the board?
It could, if you want to adopt a separate rule because you have a 27-member board. But generally speaking, Craig, the answer is no.
Okay. Guys, I've lost complete control. There's 90 questions. I can't even read them fast enough. I think what it's really telling us is we're going to have another session on elections and meetings. And maybe we do that on the 3rd, and I can address some of these specifically. And Spencer, maybe if you're available, that would be wonderful. But I want to move on to kind of wrap up on the legislative forecast. It's something we've been doing for the last several sessions just to get an idea. And we do have Spencer here who is actually writing the legislation. So Spencer, can we start with you? What are you working on from a legislative standpoint? And then Michael, I'll get you to give us an update on where CAI and your legislative team is.
Sure. So I have a couple things that I'm working on and still kind of fleshing out the details on, and I'm happy to go into 1 or 2 of them. But what I will say is that I want to talk to everyone, both advocates for the associations and for the developers, and of course for the unit owners. And I think that's sort of my perspective, is advocating for the unit owners just by the nature of the job. But when I do propose legislation, I want it to be palatable for everyone. And I actually want it to be useful and be passed. I don't want it to be overly burdensome for associations, but we do need to change some things to make life better for unit owners and to cut down on the corruption in associations throughout the state. So one of the biggest things in my mind is modifying the law on websites. As it is now, only associations that are 150 units or greater have to have websites. And what I see is very, very often, it's the smaller associations that are the ones that are corrupt, that are embezzling money. And, a lot of times it's elderly unit owners, it's foreign unit owners that just, don't have the time, don't know what's going on, or the elderly ones, less sophisticated people that don't know how to read financial documents, don't know how to put evidence together to hand to the police. and that aren't managed by, big management companies such as yourself or the other ones throughout the state, maybe aren't even managed professionally at all. So a lot of times what I see is it's the smaller associations that are the ones that are the most corrupt, well under 150 units. And in my mind, I don't think a website or even just a Dropbox where you scan your documents and put it up is too much of a burden. I think that's, really standard in any professional setting that you want to look at just to scan documents. So that's one thing that I really do believe in.
Spencer, couldn't we do away with the official record requests for the most part if everything, all the association's records were posted in a Dropbox type setting?
It's a great point. And I think that whatever cost is associated with the time and scanning of documents and putting in a Dropbox, it'll pay for itself. It'll even be profitable over the long term for associations that now don't have to work out the logistics of record requests, and people don't have to send requests, certified copies in the mail and then coordinate on the time to go in there and be supervised. So in my mind, it's a no-brainer.
Between you and Michael, you could put together some really good legislation on that.
Happy to do it.
This isn't probably not, we don't have the time or the forum, but Spencer, I think your point's very well taken. I have my thoughts on the website requirement, which aren't necessarily in line with yours. They don't disagree with yours. They're kind of separate on other things. I do want to clarify one thing, and I know you didn't mean this, but I want to clarify for the listeners. It's because of the change in the law. It's not 150 units in an association. It's 150 units in a condominium. And that's relevant because you could have a community that has a multi-condominium community that has 1,000 units, but it's 10 buildings of 100 units each. They don't have a website requirement in that community at all under the current state.
Someone had a good lobbyist to put that in because I was really surprised. It really took a lot of the emphasis out of that.
Yeah, they changed that single word so that did change that. So there is some things to look at with regard to the website. The only thing I'll say about, Jeff, I love your point. The only thing they say about that is you're going to have, there are communities, there are people who do not use a website. And if you were to say, hey, because we have a website, we no longer need to open access to official records. It just won't fly. I can tell you for a fact it won't fly.
If the record is on the website, then the association should be able to not have to comply with the official record request and direct them to the website.
Right, and that is in the law now.
They should. No, that's not.
No, it's not.
You absolutely not, Spencer.
We still have to provide them the record.
You cannot use the website as an out. If someone makes an official record request, you cannot, and they do it properly, you cannot say to them, see the website.
We wish we could. We'd like to be able to.
I would suggest that maybe you just write that down in your legislative agenda, you guys. Michael, anything from CAI that's coming our way?
And I will invite everyone, hopefully everybody on. We'll come back in February 3rd. Spencer, hopefully you can join us again, because I definitely think we have a lot more to talk about. This is a great subject, and we'll get more into virtual meetings and things on the election itself. And at that point, we'll get more into legislation because session starts in March. But the one thing I will point out is there's a draft bill that we have pushed forward, which is not a flaw bill this year. We have our points, but everybody is kind of putting their stuff, the home builders, the DBPR, the Florida Bar, all different organizations, the CEOMC, which is your management organizations. They're all putting their desires and wants into this one draft. So it's a cornucopia of items, most of which I think are excellent. Or at least very positive. But there is some issue, we talked about this, with rental restrictions, both long-term rental restrictions, and I did what's not in this bill, which is a separate bill I saw filed 2 days ago, is another short-term rental bill from the Airbnb VRBO lobby group. So that is going to be back in play. So there's going to be a lot to work with. Again, play our offense and our defense. But do come back February 3rd. We'll get more into it.
Yeah, guys, I'm going to wrap it up here, and thank you very much for your time. Spencer, quickly, though, can you give us your contact information? We've had lots of people reach out. How do they reach you? Oh, here's right here. Spencer Hennings, Ombudsman, myfloridalicense.com.
So it's ombudsman at myfloridalicense.com.
Okay.
And you can also call our office. It's 954-202-3234.
Okay, well, we posted that. So, guys, I will thank you very much for a very exciting time. I think we're going to have to revisit this on the 3rd. I will go through all of the questions that were emailed in and chatted in, and come up with some summaries, and we'll address it. But thank you very much for your time, Spencer. Thanks for joining us.
Thanks for inviting me, Craig.
Always a pleasure. Listeners, thank you very much. Have a great afternoon, and we will catch up soon. Take care.
Bye, everybody.
Bye, everybody.
Thank you.
Take care, guys.